Correct.
Thank you, everybody. Welcome back. We have our first online submitter, Mr. Barnard Thompson. Are you there?
I'm arriving.
Right. If you could just turn on your camera, we can hear you and we can see you. Can you hear and see us?
Can indeed.
Okay, well then we've received your evidence in advance. Thank you very much for that. You are not, we don't consider you to be an expert planner, so you can read your evidence to us or summarise it for us. We have read it, so maybe a summary if you're just happy to do that.
Yes, absolutely. Yep. No, I'd like to reinforce some of the points that we made in our written submission, and I was just admiring the picture of that. I think that on the screenshot there, that was Rawene, isn't it?
Yes.
Yes. Okay. Yep. I was there late January, so it's just there's a little puzzle shop or game shop there, isn't there? Which I thought was quite impressive. Yeah. So. Yeah. No, that was good. Anyway, it was a trip down memory lane there for me, so that was quite nice. Yeah. But anyway, back to the point in hand. And so, listen, thank you for the opportunity to present to you. So obviously we've made our written notes that you've read, and really we just want to follow on from the points that we made to the rural zone hearing late last year. And really we want to echo our concerns communicated at that time. Essentially what we're trying to do is get clarity for the status of relocated building in the various zones that are covered by this hearing. So new buildings built in situ are noted as having permitted activity status, and we also consider that this status would also be accorded to new buildings that are transported to a site fully built up. However, in our reading of the plan, this status does not appear to apply to relocated buildings that are not new. So the definition of relocated buildings, which is more than 2 years old that have been removed to another site, in our reading of the plan is only referenced in relation to the Carrington estate. So this therefore calls into question what the status of relocated buildings that are moved into any of the other zones, including those covered by this hearing. And in our view, without a definite status noted in the plan, it can only be assumed that these will fall into the default rules for discretionary status. I would not consider that this would provide certainty for property owners that wish to use an existing building from another site, and in fact we believe it's a lost opportunity. I'm sure you're aware the cost-effective nature of recycled building and the ability to provide for new housing more quickly than those built on site is an advantage that the Far North Council should take advantage of. Further to that, we've been making submissions to district plans around the country since 1998, and in general we seek consistent rules from one council area to another, unless there is a relevant local environmental reason to vary from this. In our view, this aids compliance with the requirements for relocations and compliance with the reinstatement process of a building once it's moved to a new site. We think that the terminology referenced in the Section 42A report, that new means new to the site, is a concept that we've not come across in our submissions to more than 50 other council district plans around the country. I believe it would be more than unhelpful to use this approach to include relocated in the definition of new buildings. As I point out in section 3.4a of my written submission, this would also be incompatible with the proposed definition of relocated buildings being more than 2 years old. Further to this approach is that there should be, or further to this, our approach is that there should be performance measures that should be complied with when a relocated building arrives to a site. And for this reason, our view is that there needs to be a specific activity control specified in the district plan for the measures to be implemented against. So Schedule 1 of my written submission details the permitted activity standards that we wish to see applied to a relocated building. So when it's reinstated onto a new site in a timely way, so that it is reinstated onto a new site in a timely way. This includes a building condition report prior to the building removed, a timeline for reinstatement that includes putting it on permanent foundations within 2 months, and the completion of the rest of the required aspects identified in the report within the 12-month period. So the specific clause that we're after and that we're seeking change of are noted includes clause 2.5 of my written submission. And really that concludes the reports that I wish to highlight in my written submission to this hearing, and to thank you for your time, and I'm more than happy to take any questions.
Yeah, thanks. Thanks for that evidence. Just looking at the provisions that you seek for relocatable buildings, and
Yep.
what you're putting to us, we acknowledge that. That's a lot of provisos for a permitted activity.
Agreed. So these are performance standards that we have seen councils around the country implement in many district council plans around in the last, I don't know, 20 years really. And so really it stemmed from that Environment Court case that we took against Central Otago, and that was the approach that was agreed by the council and well, in fact, the commissioners, sorry, the hearings panel in that case. And as I said, it's been very successful, is all I would say.
Yeah, is the wording the same that you're looking to have here?
It is pretty much standard. Sometimes individual councils want some slight variations, but really, so when you look at what's in Schedule 1, that's very common across a number of different councils. And so yeah, so there's nothing unusual or different in those ones really. Like I say, just some minor variations in different council areas, but they're pretty standard and accepted.
Yeah, it just seems that the wording is rather subjective, like when you look at Rule 3, the reports shall include a certification by the property owner that the reinstatement work shall be completed within the specified 12-month period. Yep. What happens if the property owner doesn't do it within 12 months?
So in that case, what we've found is that often there are, I guess, a number of measures that for, I guess, all the way through to like abatement notices and notice to fix and all sorts of other things that can be used. In our experience, good contact between the person conducting the reinstatement and the council about when they've completed that 12-month period means that often that doesn't come into being, or I guess a more cooperative approach is taken rather than a heavy-handed approach by the council.
Yeah, I'd put it to you that some of those measures you just mentioned are quite ineffective in reality. If somebody doesn't comply or abide with those sort of provisions, it just seems to me that it can particularly if there's people in a neighbourhood that are concerned about it, that there's not enough teeth given a permitted activity status to follow through, that maybe a status of restricted discretionary might be more appropriate. Or am I sounding too conservative?
Well, I would argue that you are being conservative there. So you'll see, so if you go to Schedule 1, so you'll see that we have a table there that on the right-hand side suggests that where there are issues that the building owner and the council think that can't be complied with within the 12-month period, then it does default back to restricted discretionary, and therefore then there is different rules and timing and requirements put on that house owner if they don't commit to that, completing that within the 12-month period. I think what we've found, so the building conditions, the building pre-inspection report, we've found is a particularly good tool. So what happens is that like an LBP or someone from the council goes through, makes the report on the building, identifies the things that needed to be upgraded within that 12-month period, and then that's known in advance of the building consents being issued, and as we said, the certification from the property owner to say that that's the work that they're going to complete within that 12-month period. We found that's a pretty good way of identifying what needs to be done to bring it up to a reasonable standard, and then that the process proceeds from there.
So is that your experience across the country within, I mean, I know you referred to a number of authorities, but is that the experience pretty much uniform across the country for what you've looked at?
It is. Yeah, I mean, like I said, we've found that this process seems to work quite well. It is interesting that a number of councils don't require these performance standards at all, but we believe that it's useful, particularly if it's being moved into an area where maybe the neighbours are a little sensitive about the fact that the house has just arrived on site, and knowing that yes, that there is a agreed completion timetable, and that it does seem to work.
Okay, thanks. Yeah. Questions from you?
Yeah, I was just wondering if this is for sites that have already had a building previously, or is it either either?
I would say either either. Yeah, I guess often it's new sites, and so I guess it depends on whether there are any particular rules or covenants around that. Obviously, if there's not, then obviously then you can get a relocated building onto these sites. It is probably rarer that a building is moved onto a house where there was an existing site, or an existing house there, sorry. But I guess if a house, for example, if it is on a larger section and it's moved backwards so that a new house can be bought on the front, so I guess that's an option which helps with utilising the land more intensively.
And what about the assessment of environmental effects? When would, how would that be triggered if there was going to be on-site wastewater or water tanks installed as well?
Yep, so that's all part of the normal building consent requirements.
Okay.
So basically, have normal building consent for new foundations, which are typically timber piles for a relocated building, and then for the service provision as well. So all that's part of the building consent, which should be issued before the building arrives to site.
Perfect, thank
Yep.
you.
Yeah, yes, good morning.
Morning.
The council officer's response is that this activity is provided for within the definition of building, which is quite a broad definition. Are we still running with the notified definition of building, or has that been tweaked since?
Not as yet.
No, so we're running with the notified definition of building, which is quite broad. And it seems to me that that's sort of the biggest impasse between your evidence and where the council stands. Is council says, well, we've got a pretty broad definition of building. Why can't we rely on which includes, in their view, relocated buildings? Can you just give us some further evidence as to why, or do you accept that statement, or why that's not enough?
Sure. So it looks like to me that the definition says new buildings or structures, right? And I guess that's what it really comes back to, is what does new mean? And if, I don't know, I guess I go to the every person in the street sort of approach, which is if you ask somebody whether a recycled building turned up to a site is a new building, I would say that probably most people would opt to say that's not a new building. A new building would be a new transportable building that arrives like one of the new transportables, like made in a factory, or maybe it's newly constructed on site in situ, right? I would have thought that it would be useful to have a relocated building definition that includes that is not a new building, especially when there is a relocated building definition there. It's the confusion between the two of them, and that relocated building only applies, I believe, to that Carrington estate. That's the only time it's referenced.
So I think what you're referring to is the rule R1, which says new building.
Yep.
Whereas I think the council's 42A report, correct me if I'm right, you're saying that it falls within the definition of building, right? So what we're talking about is not so much rule number 1,
Yep.
but the definition of building in the definitions section. Have you had regard to that?
I believe that I did.
So, I mean,
I'm just having a look here.
I'm happy to read it out to you. I've got
Yeah, okay. Yep, that'll be useful. Yep.
I had it up and then I switched on to R1.
Okay.
So I'll just clarify that with Ms. Trinder. I mean, that's the point you're making, is it, that it falls within the definition, the broader definition of building? Is that correct? Yeah. So that definition means a temporary or permanent, movable or immovable physical construction that is partially or fully roofed and fixed or located on the land, but excludes any motorised vehicle or other mode of transport that can be moved under its own power. So I think that's, and correct me if I'm wrong, Ms. Trinidad, that you're saying, or council is saying, that a relocatable building falls within that definition.
Yes, that's correct.
Yeah. So I think that's where council's sort of coming from in the first instance, is we don't need a specific definition because it falls within that quite broad definition already. And I suppose that what it then falls down to is how well it fits then into Rule 1 or subsequent other rules and other zones.
Yeah, well, I guess you got the term new building, haven't you?
Yeah, so is that your issue, that when it comes to the rule rather than the definition, that there could be a potential conflict, or a processing planner goes, how do I does this relocated building fall within the ambit of R1 new building? So what I might do is I might actually put that question to the council. Would you be prepared to give us some sort of clarification on that?
Yeah, I think when we read the R1s, it's new building, not necessarily new building. That's our intention of it. And if you look at it against, so we've got R1 new building, then we've got alterations to existing building. I think certainly the intention is to apply those provisions in a way that is enabling. And I think the overall wash up, in other words, without the additional recommendations for performance standards, kind of highlights how light touch, I think, the approach to relocated buildings council has taken. I appreciate Mr. Barner's concern, and it may be considered though, but I think in the wash up, I've no concern about it being implemented in a very clear way.
So it comes down to this multiple meanings of new. So, I mean, Mr. Barnes is concerned that new means brand new, and what you're saying is, no, we mean new as in potentially means another.
Essentially, it's new
another
construction
building
on the site.
Yeah, so a new building, so you're saying the interpretation of new building in R1 is, and that's when it comes to a relocated building, is another residential building. The introduction of a new building, but not necessarily freshly constructed new, but another residential building in that sense, that broader interpretation of what new means. I suppose my question to you then is, would that put a processing planner potentially in a difficult position in terms of trying to understand what new means?
So the approach that would be taken is that we wouldn't have necessarily a processing planner. We would get a building consent application and a planner would review that building consent application. Yeah. So that's how planning would become the interface with those proposals. Yeah. So there'd be one person generally, I would say, or a single point of task that would be implemented consistently through here. And it would be a building consent level, and it would be tick across, and we can advise necessary interpret it, but I can't imagine it would cause too much of an issue. I think it's probably consistent with our existing. Does it operate a plan? Maybe it might be helpful to also provide a little bit of comment on how it works in the operative plan.
Yeah, as well. Maybe, because what I think I'm hearing is Mr. Barner Thompson says the plan needs to be specifically enabling for relocated buildings. It's an important element of the mix of housing provisions. And I think you're saying is, well, it is. It is quite enabling, and it's enabling in the definition, and we believe it's enabling in the rule. I think what Mr. Barner Thompson, I think what you're saying is, we'd like to really make sure and have it specifically mentioned, and I think that's where the tension is.
Absolutely, no, yes.
Can I essentially just add to the definition and includes relocatable buildings?
So it's a national planning standard definition.
Yeah.
So you can't add to a national planning standard definition?
I would say I would be reluctant to this one yes.
So the answer is yes, but you'd be reluctant.
Actually, I would have to get back to you. I think we have to use them. I think so. I would say that it's probably very limited if he's going to do so. I would say we have to do probably provide another definition as opposed to rely or amend on, maybe rely on this one, but rather than amend the existing definition.
Okay. How about this then? I mean, is it possible we add an advice note or some statement to R1 that clarifies that new includes a relocated building?
So I just want to quickly say that we already have relocated building that we added to Rule 1 header.
Yeah.
So I think that helps.
Oh, okay, so that's a new amendment
So
provision.
yeah,
I'll get open those.
building and structure.
Right. My apologies.
Yes.
New buildings or structures, relocated buildings or extensions or alterations to an existing building or structures.
I've just opened that up, so please let me catch that.
So even if there is some...
Right, yep, I've got it. No, so Mr. Barnett-Thompson, have you got, or have you read the recommended marked up changes to the general residential zone provisions? No, I can't hear you. Are you on mute? Or have I gone suddenly again?
Sorry, I think I'm back. Is that right?
Yep, good. Yeah,
Yep,
please
okay, cool,
start
sorry.
again.
Yeah, no, I don't think I've seen those marked up provisions, sorry, yeah.
Okay.
Hmm.
Mr. Are you happy to explain what you've recommended to Mr. Barnett rather than me sort of give you a bad reinterpretation of it?
So this is a plan-wide submission that has gone through various hearings. It was first heard at Motorola Island was the first hearing that we considered the addition of relocated buildings into this Rule 1, and we've rolled that out consistently throughout the zones. There was further evidence presented at the oral hearings, where Melissa Pearson also responded to this in her right of reply.
Yes.
Essentially, her position was that you to decide the addition of relocated buildings in that rule as well.
So her wording for hearing 9 is the same wording you adopted here?
Correct. It was originally rolled out of the Motorola Island
Right, okay.
and we have consistently rolled that through the zones.
I'll explain that then to Mr. Barnett-Thompson. So, Mr. Barnett-Thompson,
Yep.
so basically the changes that have been recommended to the R1 rule for the general residential zone, and they're saying, and consistently in all other zones where these types of residential buildings are enabled, is the heading now of the rule is new buildings or structures, relocated buildings or extensions and alterations to existing buildings and structures. And permitted standard 1 says new building or structure, and they've added the words relocated building or extension, blah, 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 blah. And then permitted standard 2 also specifically lists relocated buildings as well. Anything else I should bring to his attention? Those are essentially those changes?
Yeah, that's essentially the changes.
Yeah. So, so what we've got is, so I think Council's response, I think Council understands your concern. I don't think the Council officers disagree with the issues that you're raising. I think it all comes down to them saying to you, have confidence that we've already addressed this. It's covered in their definition, their very broad definition of building, and they've made specific recommended changes to all rules that refer to new buildings or structures to include the words relocated buildings as well, and that follows through into all the permitted standards. Is that a fair summary?
That's correct.
Yeah. So I'm sort of wondering if this is news to you, you might want to ponder that. But otherwise, we're wondering whether that sort of really addresses the nub of your concern, and possibly whether that takes away the need to write more specific provisions as you've suggested.
Yeah, I think that probably it covers our concerns. I suppose the only thing for me would be around, you've got the definition of relocated building separately, right? Which I think is a building more than 2 years old. So I guess it's just, is there some consistency there, that's all.
Whereabouts is that provision, Steve?
The definition of relocated buildings.
Is that an unchanged definition?
It is not a national planning standards definition. I believe that would have been rolled over from the
Okay, but there hasn't been any changes, recommended changes to
no
it?
recommended changes.
Okay, so let's just have a quick little look at that. So that's relocated building.
That would also be addressed in the definitions hearings.
Oh, I see.
As well,
So-
so it's bundled up with that.
Ah, right. Well, let's just go to, right, so the definition of relocated buildings means a building or more than 2 years old. Is it your issue with the 2-year issue, is it, Mr.?
Well, I think it's I haven't seen that anywhere else before, to be honest. I'm not quite sure when a relocated building becomes a, like a recycled building, I suppose. Yeah, I'm not quite sure where the 2 years come from. Just haven't seen that anywhere else. Yeah, like
So
generally, we wouldn't place an age limit on that. If it's a new building, then it's a new transportable. If it's a reused building because it's been used somewhere else, then it's simply a relocated building.
Yeah, right. So what your concern is with the 2-year qualification in that definition, and you're
I think
not
so.
otherwise concerned with it?
I don't think so. I think that's okay. I guess it's just so if your building is up to 2 years old, what is the rule for it? Where is it covered? Just under other buildings, or it's just buildings in general? Is that right? I just wonder why there's need for the timeline on there. That's all.
Yeah, the building says it has to be more than 2 years old to be a relocated building.
Yeah.
So it must be just a new building.
But
So
then
it would
again,
fall
Be covered by a building, be covered by a building.
And you haven't gone into that because it's in your definitions section?
Yeah,
Okay.
Ms. Pearson addressed this in her right of reply for her hearings. Essentially, relocated building definition will be addressed in the hearings.
Okay.
Hearing 17.
Okay.
I have not specifically addressed this definition.
okay, and so that would be looking at this 2-year thing. I'm
Yeah,
just sort of wondering
yeah.
why does a relocated building have to be more than 2 years old?
Yes, I think that requires some further.
Yeah. Or is it so a building that you move onto a site that's less than 2 years old, is that just a building?
The way it's set up, it would be covered by that. But yes, I do think.
So Mr. Barner-Thompson, I think what we've got is Council's position. I'll just summarise that again and include that definition as well, is that a relocated building is included within the quite broad definition of building that comes from the National Planning Standards. Council's recommending amendments to R1 and all similar rules that refer to new buildings to specifically provide for relocated buildings in the naming of that rule and in the permitted standards. We understand that you've still got concerns about the definition of relocated building, and that is primarily about why does it have to be more than 2 years, and what we're being fed back is that is going to be addressed at another hearing, which will be the definitions hearing. Is that 17? Hearing 17, where we sort of wrap everything up. So I think it's sort of, I think Council's position back to you is, we think we've addressed all your concerns except the relocated building definition, which we're going to address at another hearing. Is that a fair summary? Yeah. So over to you.
Yes, listen, I think that is a useful summary. Well done on synthesising all that. And listen, I think we would be happy with that approach. I think, as I've outlined, our preference is still for those performance measures to be put in there, but it sounds like the way that the proposed plan reads that it's just need to comply with the normal rules for building in situ. That's really what the proposed plan is providing for, and I guess that would also be acceptable to us.
Okay. So
Yep.
on that basis, I think we'll probably just look forward to seeing you again. I think you probably will need to turn up to that hearing and certainly let us know
Yep.
your thoughts on any changes to that definition. Yeah.
Yep. No, the relocated building definition. Absolutely. Yep. No, that'll be fine. Yep.
Is there anything else you'd like to put to us while we've got you here?
No, I don't think so. I think that that's no, it's been a useful discussion and interesting to engage. I guess it's yeah, as I said, we've been involved with a number of different hearings around the place, but I guess there's always more than one way to achieve the same outcome. So that's good. Yeah.
Just before you go, I just want to see any questions or clarification that you think Mr. Arnold Thompson should be aware of? Any other comments you'd like to make?
I think it would be maybe helpful to the panel maybe to understand the impact of the additional standards in terms of costs.
The standards that they're proposing?
Correct.
So your question
is that there would be some crossover with the building consent process, but panel might be interested to understand what those costs might be.
Yeah, so look, I think what the question of clarification that's come from council officers is if council were to implement the additional standards you're recommending, what potentially the cost implications of complying with those may be?
Yes, so there would be costs associated with the preparation of the report, and obviously that would be on the house owner. There would be the processing, I guess, the acknowledgement of that from the council side of things, but that normally goes in with the building consent, so the same time as that, so it sort of gets all rolled into one. And then I guess there's just, I suppose, the reporting back of the completion of the timeline, which once again is reliant on the building owner providing that information and then the council processing it, I guess, to say that, yep, those performance measures have been complied with.
And I'm assuming that those would be recoverable costs from the council's perspective?
Any processing.
So that's something to bear in mind, is that
Yep.
I think what council officers are signalling back is if we do go down that path, it may actually involve additional processing and assessment costs, which would ultimately land on the applicant, and whether you might want to bear that in mind, as opposed to the regime which I think is being presented to you.
Yep. Yep.
Being presented to you today. So, okay, no, that's good, and you know, you might want to think about that and see. We'll see you again at hearing 17.
Lovely. No, appreciate the opportunity to talk further about this then, and we'll do some thinking about the points that you've raised. Yep.
Yeah, I would encourage you also too to feel free to contact council officers to talk through these issues, because they are sort of quite district-wide. So yeah, so we'd encourage some discussions prior to the next hearing, with hearing 17, if that would help you.
Okay, all right. No, that would be useful. I think particularly so we can get some agreement on that relocated building definition. I think that would be useful to get a consistent approach ahead of the time. Absolutely. Yep.
Okay, well, great. Well, thank you very much, and we look forward to seeing you again.
Thank you for the opportunity. Appreciate it.
Cheers.
Cheers. Yep.
So we just have Paul, not Rob.
Yeah. Yeah, so Mr. Anderson.
Hello.
Good morning, sir. How are you?
Good morning. Not too bad, thank you. Nice to see you again.
Thank you. Welcome, welcome back here. You're giving evidence for us today on behalf of Mainfreight Limited.
That's correct. Yes.
And we just have yourself today. Mr. Croft isn't going to be here. Is that correct?
No, sorry. Mr. Croft has just come back from an extended vacation and is busy catching up on numerous jobs, so he couldn't make it. My apologies.
No, that's fine. Well, we have read your evidence, but we're quite happy to have a summary of it for us today. Now, we've got plenty of time, so feel free to highlight the matters that you particularly want us to focus on.
Very good. Thank you for that opportunity. So yes, I prepared the submission on behalf of Mainfreight. That's before you at the moment. The main concerns that were in Mainfreight's definition was the lack of permitted activity status for industrial activities in both the light industry zone and heavy industry zone. And that was somewhat compounded by policy I can't read my own writing now, I think it's P3, which sought to avoid heavy industrial activities in the light industry zone, and we weren't quite sure what that meant, and industrial activities were expressly permitted in either zone. So that was the first concern. The second concern related to the limitation on the size of buildings in the light industry zone. So the maximum permitted size was 450 square metres of floor area, which we didn't consider appropriate for a light industry for an industrial zone or light industry zone. And added to that, we were concerned that building size was being equated with what might be light and what might be heavy industry. In association policy P5 talked in the light industry zone, discussed the amenity of the light industry zone and sought to sought to make sure that the character or the feel of light industry zone was retained, which we equated with that 450 square metre rule as well. We also sought to increase the height, maximum permitted height in the light industry and heavy industry zone from 12 metres to 20 metres. And finally, we thought the front yard landscaping rule could do with some amendment because it didn't appear to actually require front yard landscaping. So the Section 42A report and suggested amendments have gone some ways to addressing that concern. So industrial activity has been provided for in both the light industry and heavy industry zones as an expressly permitted activity, which we're glad about. However, there's been, we suggested a definition of heavy industry be provided so we knew what heavy industry meant because there was that policy. But the rule structure is such that we have light industry permitted within the light industry zone, but separate industry, as it's been called, which we assume to be heavy industry, is not permitted. That's, I think, a discretionary activity in the light industry zone. And then we have another category again, which we didn't pick up on in our original submission, which is offensive trades, which is something that's defined quite separately within the definitions and quite succinctly. So we are a little bit concerned that this new definition of light industry talks about activities that may give rise to objectionable odour, dust, noise or elevated risk to people's health and safety, and therefore some sort of assessment is required of that particular activity before you can decide whether it's actually an industrial activity or a light industrial activity. So we think that there is a concern there with regard to the rules being unclear, or at least requiring an assessment before you can decide on activity status. The 12-metre height has been amended within the heavy industry zone to 15 metres, and it stayed at 12 metres within the light industry zone. And the front yard landscape rule has been amended, but we've still got some concerns about that, which I'll get onto in a moment. So in my evidence, I I try and address what, in my experience, industrial landholders are now building in terms of warehouse and logistics activities, and the 12 metres that's suggested in the light industry zone, that would be sufficient for one of Mainfreight's freight terminals, for instance. But what we're increasingly seeing nowadays is a lot more logistics type facilities, and they tend to be built higher, around about 15, 16 metres to the knee of the building, and then you'll have the gable roof above that. And that's all to allow racking, because the logistics facilities tend to hold a lot of stock, and they now do that much more vertically than was done 10 to 20 years ago. So we're getting these higher buildings, which recognises the shortage of land in particular and efficiencies in building. So I'm concerned that 12 metres and 15 metres is not necessarily enough as we move forward over the life of this plan change to provide the sorts of buildings that are now being built. Added to that, I discuss the policy that relates to the amenity and of light industry zones, and I note that I think it more appropriate that amenity is focused on the streetscape and on the surrounding more sensitive zones. The way I read the policy at the moment, it tends to focus on amenity within the light industry zone, whereas in my opinion, the light industry zone and heavy industry zone for that matter should be providing the most efficient form of development within the zone, whilst protecting the streetscape and protecting those sensitive zones. The heavy and light industry, as I've already mentioned, I still have a concern with. It's the first time I've come across the attempt to separate light and heavy industry within a rule structure of a plan. Certainly there's always a heavy and light industry zone, but usually industrial activities are permitted in either. In my opinion, it's not necessary. I believe that the separate definition of offensive trades, I think that's suitable, and I think the restriction on the establishment of offensive trades within the light industry zone is appropriate, but I don't think there's a need to go any further than that. So my recommendation is that simple industrial activities are permitted within either zone, whilst offensive trades are limited to the heavy industry zone. And I also just added a side note in my evidence that I think non-complying might be a bit tough for offensive trades within the heavy industry zone. The front yard landscaping rule I've addressed. I still don't think that the amendments are sufficient, and the reason I state that is there's no, from what I can see, there's no minimum front yard setback requirement, so that's achieved by the landscaping rule. And the way the landscaping rule is written in the suggested amendments is that that area that's not occupied by buildings needs to be landscaped. So theoretically, you could put your building hard up against the front boundary and have a vehicle crossing there, and you wouldn't be providing any landscaping at all. So I've recommended a rule in there that seeks to combine, or amendment to that front yard landscape rule that seeks to combine a front yard setback requirement of 2 metres and requires that that entire area be landscaped. So that's a summary of my evidence, and I'm happy to answer any questions.
Yeah, thanks for that, Paul. Just a couple of things. You know, your last provision relating to landscaping and the like, you're almost taking us back to planning the way that it was. We seem to have moved away from very prescriptive standards, and now you're sort of taking us back to this idea. But if you look at that LRZP5, ensure that built form and landscaping provides a degree of amenity, etc. I mean, that's still very subjective, really, as a policy. Do you have a view on that? I mean, or are you saying your landscaping standards would put that into effect?
So I'm just looking at
9.6 and 9.7 of your evidence.
So what I've looked to do there is just refocus Liz P5 to look at the streetscape and the amenity of adjoining zones. So I've got protect the amenity of adjoining and more sensitive zones, and I see that supporting the rules, the height in relation to boundary rule and the front yard landscaping rule.
Okay. The other one just relates to height, and we've had some discussion on height earlier in the day. You know, there's 20 metres is 20 metres batting for too much? Are you being a bit conservative and batting for more than you need, or can you tie that back to be more prescriptive in the way that you have on the landscaping?
I thought about that for a long time, and I'm not particularly familiar with the far north zone. I've done a few jobs up in the far north, but not a lot. 20 metres would be very enabling of everything that could happen up there within those industrial zones. I don't think that it would often be realised. It's been 20 metres here in Auckland for quite a long time, but we're only starting to see buildings that approach, and I've had a few that have gone beyond 20 metres. That may be a while before those sorts of developments happen in the far north, but it comes back to my thesis that the main thing that we're looking to protect within those the main thing that we're looking to protect with the height is the amenity of those adjoining adjoining more sensitive zones such as residential. So if we've got a height in relation to boundary rule and a yard setback rule, then that's achieved.
Yes. Yeah. So I think the officer's recommendation was to go to 15 metres. I think it's 12 at the moment, and the officer's recommendation was to go to 15. But if it was 16 metres, for example, we might have a more reasons for actually setting it at 16 metres than otherwise.
That's right. Yes. It would provide for the logistics type buildings that are now being built, in my experience, by the likes of my clients who are larger landholders, such as the Goodmans and the Logos and Property for Industry.
Yeah. And if you need to go a bit higher than that, I guess the restricted discretionary activity provision would pick that up okay.
That's correct. Yeah, I was wondering about the purpose of the lower height restriction, and I can only assume that it's to do with the protection of the more sensitive zones, which I think is achieved by the height in relation to boundary and yard setback. And I have offered as an alternative the sort of stepped height, so you have a buffer from the residential or open space zone if height does remain a concern.
Okay, thank you. Thanks, Ron.
Yeah, thank you. Just following on from that theme first. What often we get is planners come here and tell us what other plans are doing. You mentioned 20 metres is in the Auckland Unitary Plan. I think, is it 20 metres in the Whangarei Plan as well? Or did you do a comparative analysis of what other planning? I mean, I'm assuming you do work for Mainfreight around the country, so.
That's correct.
I was assuming that you'd have this encyclopedic knowledge of every height standard for every light industrial zone across New Zealand. Well, look, I actually have the Whangarei Plan open on the light industrial height page, and it is 20 metres. And I mean, Whangarei is a bigger urban. It's a city, as opposed to far north, which is a collection of urban settlements. Would it be fair to compare those height limits to, Auckland as a major city and Whangarei as another city, or would we be wanting to do a comparison perhaps with other sort of more rural-based local authorities? And have you got any advice as to how they do it?
Yeah, it varies. You get the 20 metres, you get no height limits, and then you get some that are quite restrictive down to 12 or so metres, particularly the older district plans. I think it more than comparing between what different authorities provide for. It's just questioning what the purpose of that height control is. So is it an overall urban cityscape that is trying to be achieved in the far north, where taller buildings are discouraged, or is it one is the purpose of the height control to protect the more sensitive zones? So I haven't gone into and I haven't explored that wider approach of whether there is the city form, I'll call it, or urban form concern within the far north that we shouldn't be having buildings that exceed 15 metres in height. I haven't seen any evidence of that, but unless there is a concern with the overall urban built landscape, I do not think that a restrictive height control, and what I remember there's 12 metres, is necessary.
Yeah, okay. And look, I'm also interested in, what industrial needs are. So, it's interesting to have your evidence about what main freight's needs are. So you were saying there's a difference between your sort of standard main freight storage building and what you're calling logistics buildings. Can you just tell me a bit more about what those two activities entail and why
sure
the logistics one needs to be higher?
Yeah.
Because I think your zones need to reflect the demands of the activities that are going to be there. So I'm interested
that's fine.
in seeing where the industry is going in that respect.
Yep, certainly. So main freight transports goods from A to B, and they tend to get moved through a freight terminal, and they don't need as big a height. A freight terminal is basically a raised dock that trucks drive around the edge of. They'll stop at the raised dock, and the what we call the line haul trucks, the big B trains, will get unloaded there, and the freight will get shifted across the platform onto the smaller, what we call pickup delivery trucks, the 8 or 11 metre trucks, and shipped around the city or the district. So they don't have a big height. But what main freight and a lot of other people also now doing are what we call third-party logistics. So these are stores. So your big retailers such as your Harvey Normans and Noel Leemings and so forth won't store stock on site. They will have third-party logistics providers where all their product will actually be stored. To do that, we're now looking at a lot more vertical stacking. So rather than just having a product spread across a large floor plate, it's being put into vertical racking. And so the more vertical height you can get, the more efficiencies you get out of your site. So there's a lot more racking, and we're going up in height. And there's been quite a bit of research that has been done on just getting those building efficiencies, and that takes into account a number of factors such as the cost of actually building the structure and firefighting requirements and so forth. And what seems to be arrived at is that knee height of about 15 or 16 metres. And then at the other end of the scale now, we're starting to do high bays, which are automated racking systems that go very high. We've done them as high as nearing on 40 metres now, and those are really just corrugated iron around a racking system that's imported from overseas with, I'll just call them robots, but machines that go and pick stuff out of the shelves and put them on a pallet. So that's where we're going in, and it may be a while before the far north gets to this stage, but there has been quite a bit of pressure on the industrial land supply here in Auckland, with prices going upwards of over $2,000 a square metre for industrial land. So people have been trying to squeeze more and more of it out, because certainly in central Auckland there's very little land resource left for industrial, and it's starting to move further and further afield.
I think it's because everybody tries to put houses on industrial land.
Yeah, and I'm glad that the Far North District Plan is avoiding that, because yes, that was a problem down in Manukau with the old what used to be called the Business 5 industrial mixed use, where a lot of housing got put on and a lot of land that should have been used for industry was no longer available.
Yeah, okay, no, thanks. That's quite a helpful explanation. I'm just sort of wondering about what would be the reasonable height limit that you would need to work here, whether there is. I mean, I see you've said 20 metres, and we've got 12 at the moment. You've offered. It's not like a game of poker, but you've offered. It's not a haggle, but I'm just sort of wondering whether there is a. Is Mainfreight really want to see the ability to create these logistics centres in the far north? They
haven't got any plans to do it at the moment. So I'm speaking more as a planner who does a lot of industrial work rather than for Mainfreight. In all honesty, the 12 metres would suffice for the site they've got at the moment, because they intend to put a freight terminal on there. So But as a planner with a lot of industrial experience, I would like to see greater height. So if we do come along, another client comes along and wants to put a logistics facility on there with some vertical storage, and we're talking, you know, maybe in 10 or 15 years time here, that they're unable to do that and don't have to go seeking neighbours' written approvals or the like because they're going 3 or 4 metres above a height limit.
Okay, no, thank you. That's also helpful. Now, let's turn to this whole issue of industry, light industry and heavy industry. I think most local authorities wrestle with this issue because, and the National Planning Standards clearly say you should have a light industrial zone and a heavy industry zone. And obviously, you should be looking to do industry in both. It's just that the heavy industry caters for a certain type of industry, and that's directly located to the unintended adverse effects that may occur from that activity. In your mind, and as a planner that has done a lot of this planning in the industrial space, what do you think are the main differences between what we would consider light industry and heavy industry?
I think it more comes down to those what's enabled by the regional rules, and that is the discharges to air and to the environment. So that's to do with manufacturing type activities that have smokestacks or discharges in terms of hazardous substances. And it also relates to noise, and usually district plans will have a higher noise threshold within the heavy industry zone than they do within light industry zone. But I often have clients, you know, they'll come and say, oh, can we do this in the light industry zone? And I'll say yes, as long as you're meeting the discharge to air standards and the noise standards, then you'll be fine. So yeah, I don't think that there's, I think you're moving down a dangerous path when you try and have rules that relate to light and heavy industry, because it's so hard to make a definition between the two. And my concern is, I think that it will probably work okay, but there is having that light industry standard. But if somebody wishes to oppose you, or somebody's got a bee in the bonnet, they'll say, well, we think that you do give rise to health and safety risks because you do have a lot of trucks coming and going, or you do make a lot of noise with your industrial activity, and then a judgment call has got to be made as to whether you fall within that definition of light industry. So I'd rather that, I think it would be wise to avoid that risk.
So you're saying that heavy industry is differentiated from light industry mainly because of the discharges associated with that activity, and whether that's noise or odour or noxious chemicals.
Yeah.
What about activities that could go kaboom? How does that fit in with a discharge? I'm assuming that heavy industry would also include industries that are subject to potential explosion risk.
Yes, so
if you're defining heavy industry mainly by discharge, how does explosion risk fit into it? That's a special type of discharge.
I have dealt with a few of those, and that comes down to, and I haven't explored that in my evidence or had a look at how that works in the Far North District Plan. But I can speak to the Auckland Unitary Plan, which I'm so familiar with, that has rules on hazardous substances, and you're allowed certain volumes of substances in certain zones.
So just to truncate that, so your differentiation would be the types of discharges or hazardous substances involved.
Correct.
Yeah, opposed to, so and I think that's how the unitary plan does it, and I think a couple of other plans do it, where they just provide for industry in both zones, but you have either regional provisions or air discharge provisions that determine whether you're a heavy industry or you're a light industry. Is that correct?
Correct.
Yeah. Of course, this is Far North doesn't have a unitary plan, so they won't be able to integrate the two very well. How well does the Northland Regional Plan deal with the types of heavy industry that you're wanting to use as the differentiator, does that give you clear guidance as to what is a heavy industry or a light industry?
I didn't have a good look at that, sorry. I don't know, is the short answer.
Yeah, because that's what we would be relying on if we went down that route, wouldn't we? We'd have to rely on the regional plan standards for discharges, odour, or what have you.
Yep. So the big ones are included in those offensive trades, which are those that deal with processing animals and the like, which tend to give rise to quite a bit of odour.
Yeah, but they're land use controls, aren't they? They would be land use controls, wouldn't they?
They're land use controls, yes. So that's already within the provisions as proposed. Offensive trades are listed, they're specifically defined, and they're provided for as I think it's a non-complying activity in the light industry zone.
Yeah, okay. I'll just see if I've got You've answered a number of the questions that I had for you, but I just want to make sure that I haven't got anything else. Oh yeah, jump in, Kelly, and I'll come back. I'll ask Commissioner Stratford to ask her questions. I might come back and throw a few more.
Good morning. With a higher coverage, floor area and height, do you propose having some form of stormwater on-site disposal or treatment?
Sorry, so I'm not quite sure. I'll try and answer the question. So
with an increase, with you proposing for us to increase heights in the industrial and heavy industrial zones and
yes.
Increase floor area, are you looking to manage stormwater yourself? In particular, Waipapa, we don't have reticulated stormwater or wastewater.
So the height wouldn't affect the stormwater, but increased coverage will. So it's a building size at the moment rather than an impervious area control. So a lot of industrial activities have large yard areas. So your yard might be 50% or more of what your actual impervious area is. If there's no stormwater, reticulated stormwater system on the site, then it would have to be managed on site somehow, or a discharge put to a stream. And I've just actually been doing some due diligence on a site up in the far north, and noted the rules with regard to treatment and attenuation that were within the Northland Regional Plan that would have to be complied with. Yeah. Does that answer the question?
Yeah, it does. Thank you.
No problem.
Anything else, Coach?
No.
Yeah, no, I found the thing I wouldn't mind you commenting on. This is paragraph 5.5 of your evidence.
Mm-hmm.
And sort of halfway through your paragraph, you talk about the whole issue of the definition of light industry and how you think a freight depot could be interpreted as heavy industry, and you say a freight depot could be considered to fall outside of the definition of light industry because the associated truck movements were considered to give rise to objectionable noise, elevated risk to people's health and safety. But if that were to be actually tested, it would have to be people within a light industry zone saying your truck movements and the noise associated with truck movements are objectionable within a light industry zone. I'm just wondering how credible that would be.
I think I've been dealing with Auckland Transport too much, Commissioner. Yeah, it's my experience of having to answer these questions that I'd rather not have to answer, because I fully agree with where you're coming from, but I do experience this in practice.
Because look, I am aware of a case that goes back a few years now that was Auckland related, and it was related to a freight depot operating at 2-3 o'clock in the morning.
I know the one.
But driving through a residential suburb to get there. And that was the test. It wasn't that the noise of the freight depot was objectionable for the zone it was in. It was a section 16 RMA question about the route it would frequent with regards to residential amenity and loss of sleep. So again, I'm just sort of wondering, as an example of how a freight depot might be interpreted or contrived as a heavy industry, I'm not really convinced that argument would really stand much weight. Maybe with Auckland Transport only.
It's arguments that I prefer to avoid is where I'm coming from, rather than suggesting that it's a credible argument.
Yes, sure. Okay. No, thanks for clarifying that.
Yeah.
I'm just wondering, if there's anything from council officers you'd like to add to the discussion while we're here?
Yeah, like perhaps a little bit more understanding of the role you would expect a logistics centre to pop up. And the question I guess I have in my mind is, would that be, for example, locations that are on closer to, say, ports, for example? I'm thinking of the advent of inland ports and the existing ports, whether, what was the likelihood? I mean, are these activities more likely to be in Whangarei than far north? Is the population and economic activity enough to justify a building of that nature in the far north? As a genuine inquiry, I guess, someone who has lived in that space quite a bit.
Did you pick up that question, Mr. Anderson?
Yes, it's quite difficult to hear, but I got most of it.
Basically, what is the likelihood for a logistics building that you described, and where would it most likely be located?
And I'm wondering if those would occur myself in the far north at the moment, because it is where you've got a lot of goods that need to be stored and distributed around the area. And it may not be something that's going to happen within the next 5 years, but if we're talking about a plan that's going to have a lifespan of 10 to 15 years, well, things could change in that sense. And I did have a look at the planning maps to have a look at the supply of industrial land. It does seem to be relatively limited in the far north, so they might start to get a bit of pressure on industrial land, which could be more demanding of more intensive use of that.
Okay. You got any follow-up questions or clarification on that? Okay, well, thank you very much. It's been a really helpful discussion. So thank you very much for your evidence and your attendance and answering our questions today.
Thank you very much.
Okay.
Thank you all.
So just before we move on, when you have it by just to leave IT.
Okay.
Is that okay?
Yep, I'll just let Mr. Grace know that.
Yep.
Yeah, Mr. Grace, are you there? Mr. Grace, are you free?
Hello.
Yes, good morning. We're about to launch into your evidence, but we've got a little bit of an IT issue, and we wanted to beg your indulgence for about 5 minutes while we resolve that. So what we want to do is, it's bang on 12 o'clock now, come back again at 5 past, and hopefully our little IT issue will be resolved. So bear with us, please.
No problem. Thanks for that.
Thank you. I'll just mute the room. unmute.
Right.
Good to go.
We took longer than, so give them a chance
Okay,
to
Mr.
remember
Grace
us.
and Ms. Miller. Good morning. Thank you very much. We apologise for that unanticipated adjournment, but we're back online. Everything is resolved. So we've got you, Mr. Grace, as the planner, and we have Ms. Miller as well. Good morning. Who wants to go first? We've
Good morning.
read your evidence, and
thank you.
we're happy to get a good, feel free to give us a summary. Ms. Miller, if you want to present further evidence, you're more than welcome to do so.
Thank you. I'll be here to answer my questions. Thank you.
Thanks for that. And just, I guess, just to start, I did pick up on some of the discussion from the opening statements. So I might just touch on a few of those points that were raised as I go through with my highlights, if that pleases the panel.
Thank you very much. That'd be really helpful.
Okay, thanks. Well, kia ora koutou katoa. Sean Grace, I'm a consultant planner with Boffa School and here representing Arapatama Aotearoa, the Department of Corrections. And Andrea Miller here is the Manager of Resource Management and Land Management at Arapatama. And it'd be good to have her, I think, just again with some of the opening comments, it sounds like there could be a few questions for Ms. Miller just around the activity or the nature of community correction sites, but perhaps I'll get to that as I go through my highlights. So I guess just to open, so Arapatama made submissions on the Hearing 14 provisions relating to the general residential zone, the mixed use zone and the light industrial zone. And in terms of the general residential zone provisions, as they are recommended in the Section 42A report, whilst they don't fully give effect to all of the relief that was sought by Arapatama, and that's in relation to the residential activities that it manages throughout the district. But overall, as I've set out in my evidence, the provisions that are recommended are acceptable in terms of enabling those residential activities that Arapatama manages throughout the community. So I won't go into that any further here, other than to I guess provide a bit of context between that, those residential activities versus community corrections, because I know that was one of the sort of points raised in the opening statements this morning, and there's a very clear differentiation between the two. So in terms of the mixed use and light industrial zones, Arapatama's submission points relate solely to community corrections activities. And I've set out in my evidence a bit of detail about what community corrections activities involved. But, essentially, they're service centres for, probation and other community services. And they're also hubs for community work activities. And so you're very, very much different to, the housing activities that, or residential activities that Arapatama provides for people, say, that have left custody and are transitioning back into the community. And I think there was talk about whether there's any crossover with papakainga, and in short, there's not. I just want to make that differentiation between the two in terms of what we're talking about here. Also to make the point that both in terms of the residential activities and the community corrections activities, community work and probation, all non-custodial, and just to make that point very, very clear. So in terms of the community corrections activities, it's really important that they're located in areas that are accessible to Arapatama's clients. And in that context, commercial areas, including obviously the mixed use zone being the sole commercial zone at this point, at least in the PDP, are areas that are ideal for locating community corrections sites. But equally, light industrial areas are also ideal, particularly in terms of those community work activities. So they act as like a hub where where the clients will come, they may either do work activities on site in the most part, or actually involve them congregating and then moving off to undertake, work in the communities, gardening, those kind of things. So it'll be really a point where they'll gather, jump into a van or other sort of vehicles and head off, and for perhaps at the end, if there's sort of any more questions around the specific nature of what is involved, then Ms. Miller could touch on that. And I guess in terms of the mixed use zone providing an appropriate context for community corrections sites, there's evidence of that in that there's one site in Kaitaia and one in Kaikohe, and both of which are in the mixed use zone. Those sites have been in place for some time. So just wanted to highlight that. So in terms of the relief that was sought by Arapatama, it was really about enabling community corrections activities as permitted in the mixed use and light industrial zone. And I've outlined in my evidence how this is consistent with numerous district plans throughout the country that's recently operative and currently proposed district plans. I've provided about 10 or 12 examples in my statement, and I just picked up on some of the commentary for Mr. Arneson, was it, in the main freight evidence, just around providing kind of context with similar districts in the country, and I suppose I have outlined in my evidence how community correction sites are permitted in commercial and mixed use zones in the likes of the Whangarei district, but also Opotiki and the West Coast, which probably similar districts with smaller, I guess, urban hubs. So just a bit of context there around the country. So as it was notified, the PDP included the community corrections activity definition. Now that's a national planning standards definition. So we obviously supported that. And the way that the PDP was drafted, it only used that definition in the context of specifying non-complying status for community corrections activities. Now that's specifically in, I think there's 8 or 9 zones, and then in the other zones, it's not mentioned at all. So it becomes an activity that's discretionary in terms of the activities, or the default rule, which is the activities not otherwise provided for. So not really an appropriate outcome by any stretch. I mean, that doesn't provide any certainty, first and foremost for Arapatama and its clients, but equally the council planners and the wider community, in terms of where are these activities best located, acknowledging the fact that they're critical social infrastructure, and they're apparent and present in every community around the country. So in terms of the mixed use zone, I note that it enables similar and aligned activities, for example, commercial, community, healthcare activities as permitted. Now the 42A report has recommended a discretionary status for community corrections activities in the mixed use zone. And I note, and I think there was some discussion about this in the opening statements this morning, that actually reflects the status quo. Community corrections activities, I think in the mixed use zone, that's one of the zones where it's not otherwise specified, not mentioned specifically. So, it's the defaults to the discretionary status by virtue of that activity not otherwise provided for in the zone. And then in regards to the light industrial zone, again, this enables the aligned activities, particularly in relation to those community work elements that I mentioned earlier. So, you have sites with larger yard spaces, for example, and where you have large vehicle and heavy equipment storage. Those kind of activities are closely aligned, and there are a number of examples around the country where community correction sites are actually located in light industrial zones, as well, of course, being enabled as per my comments before on that. And the 42A report has recommended permitted status in the light industrial zone, but it's actually subject to a 12-person on-site limit at any one time. That's certainly not a provision or a standard in relation to community corrections activities that I've ever seen before. But notwithstanding that, it's out of step with other activities in the zone. There's no other activities that are regulated in such a way, and I guess it would, it's one that would likely never actually be complied with. So the result of having that as a performance standard would result in resource consent being required anyway. I guess one final thing I just wanted to highlight as well. So just around the discussion this morning about the town centre zone and the like a recommendation for the inclusion of that. So Arapatama have got a further submission point on that, and yeah, in relation to community corrections sites, it would be that would seek permitted activity status as well, subject to seeing the provisions, which we obviously look forward to. So I just wanted to highlight that. So those are certainly the highlights, and I'm not sure if Andrew wanted to touch on sort of the nature of activities, in terms of community corrections sites a bit further, or otherwise we could just sort of move to any questions.
I'm happy to answer any questions if people are wanting some clarification. I'm aware that Sean's gone into some detail in his evidence, so I don't want to labour the point, but more than happy to provide clarification if the panel would like that.
Yes, I suppose I think what we'd like to know is understand more what a community correction activity would entail, and particularly anticipating the sort of questions the communities would ask if it were to be established in a town centre zone or a mixed-use zone as a permitted activity. And the reason why I think that we think the two activities are differentiated between the light industrial zone and these two commercial zones is that the commercial zones allow residential activity, whereas light industrial doesn't. So, but having said that, I'm just wondering what level of supervision is necessary or normally provided with these activities in the place where it's established. So if it was established in a mixed-use zone or town centre zone, what sort of level of supervision would you normally expect for a community correction activity?
Sure. So first off, community corrections activities don't include housing. If you were to walk past one, and you probably do quite frequently, they appear more often than not like an office building, like an MSD kind of office building. There's an exception to that, which I'll cover off in a minute. But a large portion of community correction sites activities are office-based, and they would be termed what you'd probably historically have known as a probation office. So it's people who have finished their sentence or who are on community sentences. So that they've either finished a prison sentence or have never been in prison, but they're on a community sentence. And there are usually requirements as part of them being paroled or as part of their court sentence for a community sentence that they need to check in quite regularly in with a probation officer to check they're on track, basically. The other activity that often takes place in some of the larger CCS sites, but not the smaller ones, is there can be wraparound services. So, for example, there are sometimes psychologists based there who are helping people unpick why they behave in a certain way historically, and ensuring that any kind of triggers, etc., that go on for that person are being carefully managed. Not all people who go to a CCS site require that service. So that can be there in terms of support. for some of the sites, which Sean refers to, we call them hub sites, you might also have community service component. So that's people who they have a community sentence, and it might require them to turn up once a week and they need to fulfill 100 hours of community sentence. And they might turn up once a week for 3 hours, and they might go and upgrade a playground or put in some new furniture at a plunket, or sometimes you'll see them weeding along the edge of a road. So it's that kind of thing. It's in lieu of a prison sentence. You'd get a community sentence, and then you do kind of community programs or pieces of work to fulfill that. Often those people are working, they have jobs, so you will tend to find that many of them want to come in the weekends to fulfill their 50 hours or 100 hours or whatever they've been sentenced to. They will turn up very briefly to the CCS site. They'll jump in a van with 10 other people with the spades and the wheelbarrows and the trailer on the back, and then they'll go off to the local park or the plunket or the road and come back, jump in their cars and go home again. So it really is very temporary for those people in terms of landing there and then dispersing. In terms of supervision, these are not people who are sentenced anymore apart from the community sentenced people, and they are in our community all the time. They're you and me. So they have no supervision. They're just getting on with their life and fulfilling the community sentence that the courts imposed on them. Or they're out of prison, but they've served their sentence. So they might have a requirement for a parole requirement to meet certain requirements, like check in once a month or to make sure you're on track kind of thing. But they have the freedom that comes with having completed a sentence. So they're not supervised in that sense. They get obviously informal supervision when they're inside the building, in the same way you would expect they're going to get it anywhere they go. A business owner is watching people all the time whenever they come into their building, but there's no formal supervision in terms of a corrections context to that. Does that help at all?
Yeah, thank you. That's quite a helpful description. I'm just sort of wondering, again, anticipating the sort of questions that business owners and residents would ask, is the risk of antisocial behaviour spilling out and either outside, and how does Arapatama manage that, and how do you manage that risk? And I'm assuming it happens every once in a while, right?
Possibly no more than you'd probably experience in the wider community. What I would say to you is that corrections managers very carefully the timing of things, and both within a prison but outside of a prison where people are going to be congregating, particularly around gang mix. So there is a lot of structure around not mixing known parties that could potentially behave in that way. When I talk to people who work in those CCS sites, they say people want to get in and they want to get out. They don't want to linger around. It's not a place they want to hang around. And for those people who've left the prison environment, they don't want to be associated with that anymore. This is a requirement they need to fulfill, but it's certainly not a highlight of their day. So they catch the bus or whatever, they go, they check in, they do what they need to do, and then they leave. It's not a lingering kind of place. And I suppose the other part in terms of the community is these are people who've been determined by the courts that they can either be released or parole board. They can either be released if they've been in prison, or determined by the courts that the nature of their offending is such that they can have a community sentence. So that might be someone who's got a repeat drink driving offence, for example. They might be checking in to do some community service. So there probably should be some reassurance to the community that we're not talking, we're not always talking at the higher end of the spectrum in terms of some of the offences that hit the media and cause people concern. These are often very low level offences who are coming in to check in.
Okay, thank you very much. That's also really helpful. In terms of numbers, I mean, obviously you're opposed to a 12-person threshold. What sort of numbers do you normally expect in a facility like this, and have you thought about what numbers you would expect in this district?
It's really variable, and it depends a little bit on whether we're hubbing or not. So in some of our CCS sites, they are people work there 2 days a week, and it'll be 1 or 2 staff members. They're not hubs. If there's a community sentence requirement, they've got to go to another township to do that, and that creates problems for people who don't have access to private transport, for example. But some of our smaller ones, it really is, they might be sharing part of an office with police or MSD or courts or someone, and they just come in a couple of days and they're solely focused on the check-in. So the probation, you need to check in once a month. Yes, how's everything going? Are you still living at this place? Is that stable? That kind of discussion. And then they're gone in 15 minutes, half an hour. For some of our larger facilities where you've got so you've got the psychologists in there, you've got the community service, community work component, etc. They'll be larger. But generally speaking, if you've got a facility that's on the moderate scale where you've got psychologists and a number of probation officers, we would hit 12 for staff alone very quickly. You know, you'd have 2 or 3 administrative people, 10 probation officers, and 3 psychologists. That wouldn't even allow for our clients to even turn up, because the staff alone would hit that 12 very quickly.
Okay, thank you. I'll just see if the other commissioners have any questions.
Yeah. Kia ora. So your submission encompasses mostly Arapotama. It doesn't apply to, say, there are agencies which provide some of this work under contract, and because their facility or their premises aren't used solely for this, you know, like every week, like Matariki Court at He Iwi Kotahi Tātou Trust, and the counselling services that are provided there, you know, they do some stuff with the men, coaching them and stuff. So you're just speaking on behalf of when your name is up on the door, because those premises wouldn't have had to go through a change of use at all, because they're haphazardly providing these contract services. Is that right?
I think probably key to distinguish, so if you're talking about the counselling services, they might be contracted to Arapotama, maybe, or not. They might be contracted to MSD, who would know, where they're funding, or from the health, the local health board. They'll be sourcing funding from a range of places, but they would have to fit within the permitted criteria of whatever service they're offering. So if office-based counselling services are a permitted activity, then regardless of whether that person turning up for the counselling has a criminal offence in their background, that's the service being provided is still the same, in the same way that if I turned up to get that counselling service and don't have a criminal background, the planning context or RMA context is the same regardless. The rules we've never come across a district plan, apart from where sometimes they refer to detained people, which is a prison, because you're not detained for any other reason. We've never come across a district plan which will distinguish between your ability to undertake an activity based on your criminal history or background. There would be some pretty significant human rights issues going on there. So generally speaking, if they slot in, if another party is providing a service and a corrections client may or may not be using it, then they will be fitting within the context of the district plan more broadly. The only exception I would say to that is with supported housing, which is not what we're talking about here. So they might have contracted services to corrections, and we'll all be slotting in under the same rules. It won't be called corrections housing. They might be providing some form of support to people living in a house. There might be, for example, I know the Ministry of Health contract a lot of health services related to addiction for people living in certain houses. So that's what we would loosely call supported housing. Corrections may or may not have people in those forms of accommodation as well, but they will tend to be contracted services rather than corrections providing that as a direct relationship.
Yeah, okay. Sean, were you going to add something?
Oh yeah, just I guess a little bit more context around from a planning point of view. The definition of community corrections activity, I think I mentioned that in my highlights, and also in evidence, just how that is a national planning standards definition. Now, the origin of that was engagement between Arapatama and the Ministry for the Environment around 2018 or 19 when that definition was included. So it was very much focused on capturing the activities that we're talking about here, very bespoke, provided primarily, if not solely, by Arapatama, and you're only likely to ever see a very limited number of these types of facilities with any given district. I touched on the two sites in Kohe and Kaitaia that exist at the moment. It's unlikely over time that you would see too many more, and certainly not a proliferation of these facilities. So it is a very bespoke definition that applies to a very bespoke activity. And just the other point, just to, I guess, reinforce what Andrea was saying there around the supported residential accommodation side of things. So I didn't touch on it so much in my highlights, and nor do I in my evidence. We've supported the council position on using the definition of supported residential care activity. So that's one. It's not just used in the general residential zone, but other zones where residential activities are enabled. There's regulations. I think there's a number of it might be a 6-person limit that applies. Is it the best way of managing these types of activities? In my view, probably not. They fall, in my view, under the wider ambit of residential activity, but we're not willing to pursue that relief any further. We're happy where the council has landed with the supported residential care activity definition and the associated provisions throughout the plan, not just the general residential zone. So yeah, just want to raise that.
I should probably add too, I did miss one of the other activities that occurs in hubs is training. And often it's job training. So for some, and one of the reasons we sometimes like to go into those light industrial areas is one of the training, for example, that sometimes is offered is mechanics training. So that can get a bit noisy. So like any kind of activity like that, we like to stay well away from any noise sensitive environment, and that seems like a good fit. So there is a component of job training, particularly for people who have left prison and need to be upskilled so that they can, the key goal here is to start integrating people into communities, to start leading a normal life. So jobs, housing, and any kind of psychological support that they need to ensure that they can start being well-functioning members of our communities.
Great, thank you.
Yeah, good. Just a couple of things, if I may. You said in your evidence, Sean, that there's a couple of facilities, one in Kaitaia and one in Kaikohe. Are there any new sites being looked at the current time?
Yeah, big question for Andrea. Yeah, she's shaking her head.
Yeah, no, but that doesn't mean that there wouldn't be. For example, sometimes the leases come up and we take the opportunity, well, either it's not on offer anymore, the lease isn't going to be on offer anymore, or we take the opportunity to say, right, well, we might move to a hubbing rather than just an office space and a separate community service arrangement, we'll move to a hubbing arrangement and we might look for a property then. So there is no strategic plan in terms of growth, but we may need to react to the market at some point and look at an alternative site.
Okay. So
just sorry, further to that, if I might. So the model that I've seen over my experience the last 15, 16 years working with Arapatama is that the sites typically used to be owned by the Crown, and often would have a designation over the top. And in fact, I think one of the sites, maybe the Kaikohe one, has a designation over it. What's happened over time is that the new facilities tend to be not owned by the Crown, not owned by Arapatama, and subject to like a leasehold arrangement. So yeah, as Andrea said, it's and not therefore subject to a designation as well, to make that point. So that they tend to be a bit more fluid. Therefore, it's increasingly important that the zone provisions are enabling. We're in appropriate locations, of course, because there's not those, the sites aren't under that ownership and designation model that we used to see, in sort of years gone by. Sorry.
Okay. Yeah, so in the mixed use zone, I mean, the current proposal from the council officers, I guess, is to retain discretionary activity status. If you brought forward a proposal in the mixed use zone as a discretionary activity, what are the effects that would be considered?
Yeah, so that it tends to be, my experience dealing with resource consents for these types of activities, it's your normal kind of nuisance ones, so noise, traffic, and it tends to, the way that the councils approach it tends to be more of a perception rather than a kind of reality. But that said, that it's full discretionary, so that the district plan would enable them to consider all effects. But those are the types of effects that typically be asked for a traffic assessment, particularly in the tier 2 and 3 councils where we don't have the restriction or the inability to impose parking minimums. So they will still look at parking effects and, yeah, as I say, noise.
Yeah, well, really, those impacts would be pretty easily dealt with, noise and traffic. You would imagine that folk visiting these centres wouldn't necessarily have vehicles of their own, and one would presume on noise that could be managed pretty easy. So it really comes down to what you said, the perception to be looked at as part of a discretionary activity. How do you approach that in terms of providing planning evidence to address the question of perception of these sorts of facilities?
Or look, I mean, you just have to approach it objectively. Really, we would approach it like any other resource consent. We look at the actual effects and provide technical advice and reporting around those matters where we need to. Our application itself might include a bit of information around that perception and safety issue, but the reality is, as Andrea touched on before, these people are enabled to be in the community by the courts, by the system. Therefore, there should be no undue restriction around the operation of these sites through a planning mechanism.
So could that be dealt with as a restricted discretionary activity? Would that go some way to meeting part of your concern?
Oh, look, if I may, I would consider that would unnecessarily create the need for resource consent that would ultimately most likely be granted. All it would do would potentially enable the ability of the council to consider, affected parties from that, sort of health and safety or safety perception point of view, which would, in my experience, ultimately these things do attract those kind of submitters from that perspective. So you would unnecessarily create a process and risk to, Arapotama, by needing to go through the resource consent process for something that ultimately is completely aligned with other activities in the zone. You know, I touched on a few before in relation to community and healthcare activities, even commercial and the like. So, yeah, I would see it as an unnecessary hurdle to have to step through.
Okay, thanks very much. Thank you. Just before you go, I'm just going to see if council officers have any questions or clarification to help their understanding of the evidence. So, is there any questions you'd like me to direct to the witnesses for clarification?
Thank you, Chair. I think from Mr. Grace's evidence and the explanation we've had today, I've got quite a good understanding of the types of activities that they're anticipating. I don't have any questions at this stage.
Right. Okay. Well, it looks as if you've been. Oh, sorry. Carry on.
I might just helpfully throw in a statistic here, because I think sometimes it's useful when we're talking about people with a criminal background. 70% of people in the prison system have a mental health problem. So if we're talking about similarities with people in the health sector, and particularly the mental health sector, often they're the same people. So crime is often driven by a mental health issue to varying scales. So I think it's sometimes helpful to put that in context too, because often we just think people are bad. But actually, if you've got people coming and going from health facilities and mental health counselling services, etc., they're often the same people who will be turning up to a community correction site for assistance. So it's around wrapping that health and other support around people so that they are part of our community all the time.
So I think what you're saying is that this is as much a health service as it is a correction service. Is that what you're suggesting?
Yeah, so it's not designed to be punitive to people. So the checking in is for us to make sure that they are on track with their lives. Now, there are consequences if they're not. So, for example, if they were meant to stay away from a pub and we know they haven't been away from a pub, there will be a consequence. But the whole system isn't designed with being punitive in mind. It's designed to support people to reintegrate and to try and really understand what those people need, what's stopping them from reintegrating. You know, it may well be they haven't got a home, or they've got no money, they've got a job, and that's forcing them, and some will make it tempting for them to get back into old friendships or old relationships which lead to crime, right? So what needs to happen to support those people? So at that point, we're working across agencies all the time. Can someone provide a house, for example? If someone's got mental health issues, then working across not only with our psychologists, although Corrections is the biggest employer of psychologists in New Zealand, which gives you some sense of the mental health problem with our clients. Working across other agencies, what health and mental health support is needed to make sure these people are successful when they come back into the community, because generally, without exception, people are going to come back into the community. So what do we need to do to get them to a point where they actually can function and cause less harm to our communities and to themselves?
Great, thank you. Well, thank you very much for your evidence. I think it's been really, really helpful. And we understand the issues and the activities you're wanting to get enabled. And I think it's been really, really helpful. So thank you very much again.
Thank you very much, and thanks for accommodating us online. It's appreciated.
No problem.
Thank you.
Bye.
Good timing.
So Ms. Bell, still, I'm not sure we need to direct any questions to Ms. O'Connor. I think we're quite happy.
Okay.
We understand her evidence quite clearly. I might have a little discussion with council officers about that at some point. I'm just thinking, I'll break for lunch now.
Yep, we're 2 minutes early.
Yeah, we'll just
Perfect.
go back at
2 o'clock is our next submitters, yes. Okay, stopping the recording. Stop recording, and I will mute.